Good morning. This is Isabella County. Can you hear me?
Just that one.
I can, yes, thank you.
The problem is many of
Who is that, Isabella? Okay, we're looking for an Eric Lancer.
Yes. Yes, sir. He is right here. Just give me 1 second.
whether
Okay.
whether can do that for that long, she should be here.
There you go.
Are you still there? All right, Mr. Lancer, are you able to hear me okay?
Yes, sir.
Okay, we're on the record in People versus Eric Lancer. This is file number 244996. The record should reflect that Mr. Lancer is appearing today from Isabella County Jail. If I could have counsel put your appearances on.
Brian Ziegler on behalf of the people, Your Honor.
Thomas Seeger appearing with on behalf of Mr. Lancer.
Thank you. Mr. Seeger, can you tell me the status of this file today?
Your Honor, I did get a motion date from our clerk yesterday, and so there is one motion that I would like to file. So hopefully we're able to resolve that. I think the next date was somewhere in April, and so I would just ask the court to continue until that date. I haven't been able to speak to Mr. Lancer because he's incarcerated in Isabella. But Mr. Lancer, are you going to post your bond without reference to anything in Isabella or no?
No, I think I'm going to try cap after court today or tomorrow to do rehab.
All right.
For like a 150-day course or something.
Yeah, so Mr. Lancer, I'm not sure what effect that, I guess I can, your bond is open through here. So unless you ask me to cancel it, I'm not going to cancel it, I guess.
Yeah. I don't know if I should cancel it or not. I guess I don't know what would benefit the most.
Well, the only benefit would be that arguably, if you're not under sentence, you would receive credit for the time that you're serving if you're incarcerated. If you get into treatment, it may be a little bit different and the credit may not apply, but I would suspect that you probably need to have an open bond in order to go into treatment, I would suspect.
Yes. And I believe that's been set up, but I believe it's either today or tomorrow. So
okay, so I should not cancel your bond then, correct?
Yeah, that's correct. Thank you.
Okay.
Okay, so the court will just continue the status conference for the April date for your motion, Mr. Seeger, and then we'll proceed further at that time. Mr. Seeger, anything else we can address for your side today?
No, Mr. Lancer, so if you get into TRICAP, will you contact me to let me know that you're there and sign any release necessary so that I can at least try and talk to you?
Yes, absolutely. I got your phone number, so I'll call you as soon as I get there.
All right, thank you.
Thank you.
Mr. Seeger, any further?
Nothing further, Your Honor.
Okay, Mr. Lancer, did you have any questions?
No, Your Honor.
Okay, we're gonna go ahead and disconnect at this time.
Okay, thank you. Talk to you.
Your next client, Mr. Seeger.
Your Honor, the next person on the docket is Mr. Bidri. When I spoke to the prosecuting attorney yesterday, apparently Mr. Bidri is not lodged anymore. And I'm not sure if he went to another county on another writ or something. But he was at one point in time lodged in Antrim County. What happened thereafter, Your Honor, is not entirely clear.
Okay, do you have anything to add to that, Mr. Ziegler?
Your Honor, just that we, Mr. Seeger and I had a discussion about it yesterday. My staff did contact Antrim County, and they said that he had bonded out a little while ago. They did not know what his whereabouts were, so I was hoping he would be here today.
Okay. This was set for 9 o'clock. It's now 9:10. I think in light of his recent incarceration and release, the court's gonna set this for a hearing at its next date, for show cause and status conference. If Mr. Goodrich doesn't appear and we've had no word from him by then, the court will issue a bench warrant. Any objection to that, Mr. Seeger?
No, Your Honor.
Mr. Ziegler?
No, Your Honor.
And once again, for the record, that's People versus Jeffrey Goodrich, file number 255023. Mr. Seeger, are you ready on any of the 9:15?
Your Honor, I can be ready for Mr. Patrick, yes.
People versus Darnell Patrick, case number 244981. Mr. Patrick, you want to come right up to the podium there, please? Record should reflect Mr. Patrick's present here in the courtroom today, if I can have counsel.
And so going to the people, Your Honor.
Thomas Seeger, appearing with an on behalf of Mr. Patrick.
Mr. Seeger, can you tell me the status of this file today?
Your Honor, as the court is aware, we had adjourned previously to determine whether or not I could get him into sobriety court through another county, as our county was not currently utilize that particular court. And so it's my understanding that he's not likely to be eligible for that court in another county based on a variety of factors. And so in speaking with the prosecuting attorney, Your Honor, we're looking for alternate remedies. We have similar like cases which different remedies have occurred, which may be exacted in this file as well. But I think that Mr. Ziegler wanted an opportunity now knowing that sobriety court is not most likely a possibility that maybe a different resolution could be reached. And so if you give us an additional 30 days, we'll come back and either we'll resolve the file or we'll just put the matter on trial back.
Mr. Ziegler?
Your Honor, I share in that request. It's been difficult coming up with reasonable and proportionate plea offers for these types of cases since we lost sobriety court. I just found out Mr. Patrick was not going to be eligible for Antrim's program last week. I would like a little more time to discuss with Mr. Seeger some potential plea offers in this case.
Okay, do you have any objection to that, Mr. Patrick? No. Okay, so the court will set this for a status conference plea hearing in 30 days. That will be the plea cutoff. So between now and then, Mr. Patrick, just make sure that you stay in touch with Mr. Seeger. And at that next hearing, I'll need you to have made a decision about whether you want to enter into any kind of a plea agreement or whether you want to go to trial. And whatever you decide on that day will be final, okay? Mr. Seeger, anything further from your side?
No, Your Honor.
There you are.
Do you have any questions at all, Mr. Patrick? Oh, no. Okay, thank you, that's all. And is Mr. Barkovich lodged?
He is lodged, Your Honor, through Antrim County, so I'm not sure if they brought him here personally or in the alternative if he's appearing from Antrim County.
He is not here, no.
Okay. I don't see Antrim connected yet. Sure, that'd be great. Is he being held for us there, or did he?
He has charges, yes.
Okay.
And Your Honor, I'm not sure if Ms. Miller is here, but she may have been brought over. from West
She
Florida.
is either in transport or she's down there now. I can find out.
Yeah, can you check and see? Thank you. Okay, great. Thank you for calling.
This is Mr. Barkovich, Your Honor.
Okay, Mr. Barkovich, are you able to hear me okay?
Yes, sir.
All right. Now, we're on the record now. This is People versus Terry Barkovich. We've got a number of files set for status conferences today. Let's see, we have file number 255009, 5010, 5011, 5012. I only have 4 of these on the docket. Are we gonna address all the files
There
today?
should be 8, Your Honor.
Yeah, I think I've got,
Maybe there just wasn't room on the, oh, that's it, there wasn't room, okay. 5013, 5014, 5015, and 5016, so that 8 total files today for Mr. Barkovich. The record should reflect Mr. Barkovich is appearing today by video from the Antrim County Jail. If I can have counsel put your appearances on.
Ryan Ziegler on behalf of the people, Your Honor.
Thomas Seeger appearing with on behalf of Mr. Barkovich.
Can you tell me what the status is with regard to all of these matters today?
Your Honor, an offer has been extended. We're not quite ready to accept it or reject it. That Mr. Barkovich plead to 4 counts of UDAA, 1 count of escape, 1 count of home evasion third, all as a habitual offender second. And that is the current offer, which is more favorable than the initial offer. However, to the extent that we continue to discuss potential resolutions, we're not at a point that Mr. Barkovich is in a position to accept that.
Mr. Ziegler, do people have any objection to setting this out?
Your Honor, there's 8 felony files along with a misdemeanor file. This is the defendant's first appearance in circuit court, given the complexity of the plea and all the moving pieces. I don't have an objection to adjournment.
Mr. Seeger, are there any, is there discovery that you're waiting on, or is there anything other than just being able to go through the implications of the plea with Mr. Barkovich that you're waiting for?
There may be some motions that Mr. Barkovich wishes to pursue at a later date, depending on what we're able to resolve. But if there are any motions, the motions would not be hyper technical. So I generally think that we would be able to hopefully resolve the matters. If we can't, then I guess we just can't let every trial.
Okay, so 30 days for a plea cutoff, is that enough time for you to?
Your Honor, probably, I would ask the court to give us 60 days, and the only reason being, Your Honor, is because there was a file in Antrim County, which I've been discussing with his current counsel in Antrim County. I'm not entirely sure what's going to happen with that file. It's not that the 2 files control each other. 10 files control each other, but if they were going to be resolved, I assume that we would try and somewhat coherently resolve them all simultaneously. Even though I do understand that Antrim and Kalkaska are not each other in any way.
Okay. Mr. Ziegler, if this matter were to go to trial, or these matters, are you going to be filing a motion to consolidate? Are they part of the same?
They're not really part of the same transaction or occurrence, Your Honor. It's essentially a string of larceny type, home invasion type behavior over the course of probably a couple weeks at least. So I would have to look into whether or not there's case law to support joining them all together under those circumstances, maybe under a theory of a common scheme or plan, but I think that's they oppose that. So I don't have a good answer for that at this moment, Your Honor.
Okay. All right. So I guess what I'm going to do is I'm going to set this for a plea cutoff in 60 days. So if we're going to have a plea agreement, it needs to happen at that time. If we don't have a plea at that next hearing, then the court's going to schedule it for trial. We'll set some motion cutoff dates, and the court won't accept any pleas after that date. I think 60 days is enough time for the defense to make a decision about that. So that'll be a hard plea cutoff. So Mr. Barkovich, between now and the court's next hearing, you're gonna need to discuss any plea offers in this and your other cases with your attorney and be ready with a decision at that next hearing, okay?
Yes, thank you, sir.
Mr. Seeger, anything further I can address for your side today?
No, Your Honor.
Mr. Ziegler?
No, Your Honor.
Okay, do you have any questions at all, Mr. Barkovich?
Not at this time, guys. Thank you.
Okay, thank you. The court's gonna go ahead and disconnect at this time.
Yep.
Your Honor, I have Ms. Smith and Ms. Miller are the last two. Ms. Smith is in the courtroom and Ms. Miller.
Okay, let's take Ms. Smith's case first. People versus Chelsea, Aaron Smith. You can right up to the podium now. This is file number 244997. The record should reflect Ms. Smith is present here in the courtroom today. Counsel, put your
Thomas Seeger, on behalf of Smith.
Okay, this is the date and time set for sentencing in this matter. And Ms. Smith, have you had a chance to go through the pre-sentence report and talk to Mr. Seeger about that?
Yes.
Mr. Seeger, are there any additions, deletions, or corrections to that?
There are no material additions, corrections, or deletions.
Changes to the scoring of the guidelines.
No, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No.
Anything on behalf of the people for allocution today?
Your Honor, I support the recommendations contained in the report. I think the PSI and the record reflects Ms. Smith has done a good job of getting a handle on her substance abuse issues. She's been through treatment. I think she understands her issues and the need to address them. She's made some good progress in that regard. Given all of that, Your Honor, I don't think that additional sanctions beyond court-ordered fines and costs are necessary at this moment. Either she fully understands the issues and we're unlikely to have any problems going forward, or she will relapse and she'll be back and we can address those at this time. But I don't see that there's a lot of benefit to probation at this time, given the amount of progress she's already made of her own volition. So for those reasons, Your Honor, I'd ask the court to adopt the recommendations.
Thank you, Mr. Seeger.
Your Honor, likewise, I would just ask the court to follow the recommendations. To her credit, she's engaged in sober living. She's done very well with it. She has hopefully a bright future. Previously, she didn't have employment, but she's recently found some. And so hopefully that stabilizes things for her. She's expressed to me the importance of family and how she wants to be a very role model and how she wants to put all this behind her. I'm very happy for her. When I first had met her, she was maybe a little bit defiant and a little bit difficult to discuss things with. But over the course of time, and I think it's partially through sober living that she has recognized that she did have a substance use problem, that she may continue to have going forward as well. But at least she's now recognizing and addressing it. So she's hopeful that she can put this behind her. She's done very well. I'm just asking the court to follow the recommendation.
All right, thank you. Anything you wanted to say?
Just sorry for taking up the court's time with this. I'm definitely doing what I can to make progress in my journey. Still in sober living, doing AA and NA meetings daily. Just want to put this behind me, move forward.
Okay. All right. I did read through the pre-sentence report, so I'm familiar with what happened in this particular case, as well as your background and circumstances generally. It does appear to me from what I read in the report that you are making some genuine efforts to maintain your sobriety and remain clean. And I think what you just said is really important because it is going to be a constant thing that you can't really afford to relax or get away from. Having those meetings, constantly keeping up with that is going to be the way that you're going to be able to move forward. So I hope that you continue to follow through with the things that you've been doing so far. In terms of an appropriate sentence, you've been on probation a number of times. I don't find that that would be helpful in this case. There's generally two ways that the court can punish wrongful conduct, either through jail or through the pocketbook. And in this case, I don't think additional jail time is appropriate given the efforts that you've made. I think that would, put you further behind and get you off track where we've all just agreed it's important for you to stay on track. So the court's not going to impose any additional jail time. The court is going to sentence you to fines and costs, as well as the 6 days that you did serve on this charge. So the court is going to order that you serve 6 days in the Kalkaska County Jail with credit for 6 days served. A crime victim's assessment of $130, court costs $325, attorney fees of $350, $68 state costs, and a $500 fine. You have the ability to seek an appeal of this sentence. Mr. Seeger, can you grab, I don't, Terry, this last, I don't know where to go right there. Can you provide those to Ms. Aaron Smith? These are papers that are going to explain to you what your appellate rights are, as well as how to request a court-appointed lawyer to help you with any appeal.
Your Honor, for the record, returning a copy of her appellate rights, giving a copy of her own.
And then you just need to, after the hearing, just go across the way to the clerk's office to set up arrangements to make those payments for fines and costs. And otherwise, good luck to you moving forward.
Thank you.
Ms. Hiller, if you go right up to the podium. We're on the record in People versus Jennifer Hiller, file number 244956 and 244976. The record should reflect that Ms. Hiller is present here in the courtroom today.
Ryan Ziegler, on behalf of people, Your Honor.
Seeger, appearing on behalf of Ms. Hiller.
This is the date and time set for sentencing in this matter. Ms. Hiller, did you have a chance to go through the pre-sentence report and talk to Mr. Seeger about that?
Yes, I did.
Mr. Seeger, are there any additions, deletions, or corrections that need to be made?
Your Honor, I did have an opportunity to speak with probation and parole relative to some minor changes. However, in speaking of corrections, they're unable to change them based on their research. The only thing that I can specifically ask the court to consider changing would be her education level, which indicates that she has a 10th grade education, but she represents that she has a GED. But when I had spoken to the Department of Corrections, they were unable to verify that through a previous pre-sentence report. However, Ms. Hiller stated that she doesn't think that she.
Mr. Ziegler?
I don't take a position.
Okay. The court will order to that the PSI be amended to reflect that the defendant indicates she did obtain a GED. Any other corrections?
No other material additions, corrections, or deletions.
Are there any challenges to the scoring of the guidelines?
There are not. Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution today?
Your Honor, if there's one thing that sums up Jennifer Hiller, it's 115 PRV points. Ms. Hiller is 28 years of age. She has been eligible to have adult convictions on her record for around 10 years. And in those 10 years, she has 10 felony convictions. Ignoring her 8 juvenile adjudications, she has felony convictions for larceny in a building, stealing a financial transaction device, illegal use of a financial transaction device, another larceny in a building, possession of meth again, larceny over 1,000, possession of narcotics, and a third larceny in a building. This along with several petty drug crimes and petty theft crimes. Your Honor, I've been prosecuting Jennifer Hiller since the time I came to Kalkaska County in 2017, and I feel like I will be prosecuting Jennifer Hiller for as long as I remain in this office. The only time Ms. Hiller is not reoffending and stealing property is when she is incarcerated And the second she is released from incarceration, she steals again. On December 29th, 2020, she was paroled for a felony larceny offense. And on February 26th, 2021, about 2 months later, she committed a new larceny offense. She paroled on that offense on March 12th, 24, and on June 3rd, 24, she committed a new felony larceny offense and then was later arrested for that offense with meth in her possession. If recidivism were an Olympic sport, Jennifer Hiller would either earn a gold medal or she would steal one. She's not a candidate for supervision. She has repeatedly and consistently failed on probation, on parole, on deferral programs such as drug court. She's not a candidate for community sanction. She's already has 3 active parole cases in Otis and violated parole by committing this offense. Our sanctions for high severity felonies such as this, Your Honor, should not lessen over time, especially for someone with Ms. Hiller's astonishingly poor track record. There's simply no reasonable likelihood Ms. Hiller will be rehabilitated. She has repeatedly demonstrated that if she has the opportunity to steal property or use drugs, she will do so. Nothing has served to deter her behavior in the past. Not probation, not jail, not prison, not deferral programs, not parole. She will simply reoffend again, Your Honor. The only thing we can do at this point is prevent Ms. Hiller from offending in our community for as long as possible by sending her to prison for 23 months. So that is what I would ask the court to do today. Thank you.
All right, thank you, Mr. Seeger.
I can't really diminish that Ms. Hiller has a pretty extensive criminal history, and I've been her attorney since she was a juvenile, so I'm very familiar with Ms. Hiller. And it's unfortunate for Ms. Hiller. She has struggled a lot in life. She has made a lot of bad decisions. Why she makes those decisions is not entirely clear to me. She hasn't always had the best of life. She hasn't always had the easy of life. I think that she has been mixed with a lot of people who have similar life problems with abuse and drug addiction, such that it's creeped into her life and has just become a pervasive part of her life. And it's unfortunate because she's still relatively young. And in as much as I understand what Mr. Ziegler is saying, that she has a long, extensive criminal history, I would like to think that she's still capable of change in as much as she's still only 28 years old. In this particular case, Your Honor, Mr. Ziegler is correct. Originally, when she was paroled, she was charged with an embezzlement case. That case was dismissed, and it wasn't just part and parcel of a plea agreement, Your Honor. It was that they were not going to be able to prove it at trial, or at least that's my belief. Moreover, Your Honor, restitution wasn't part and parcel of my agreement because, again, I don't think that they were ever going to be able to prove it. She continues to deny it as untrue. But be that as it may, Your Honor, she's not being sentenced for an embezzlement. She's not being sentenced for a larceny. She's being sentenced for what happened in this case, which was that of her being in possession of a small amount of methamphetamine. In speaking with the probation department, Your Honor, it's my understanding the reason why the recommendation is the way that it is, despite them recognizing that she has a long criminal history, is primarily because of the amount that was encapsulated or that she was found with. It was a very minuscule amount. It was residue. There was no indication whatsoever that she was trafficking drugs. There's no indication that she was selling it. There's no indication that if anything, it was a leftover amount of residue for which she had been using personally. I say this quite often, Your Honor. I only say it for the benefit of Ms. Hiller, because she's not here every time that I do the drug sentencing of some sort, but that people who have addictions struggle with those addictions. It is a malum in prohibitum style case. It is not malum in se. And in as much as I think that is a very poor life choice for people to use drugs, it's a choice that she's made either through necessity or as a coping mechanism, or just generally making a bad choice. But she's not probably hurting anyone other than herself in that way. Unfortunately for Ms. Hiller, she's on parole. She has served a lot of dead time. I understand that the court does not take that into consideration per se, but the recommendation is for a county year. And I don't want to diminish what a county year means, right? Because I guess for us as attorneys who are in circuit court, a county year probably doesn't seem that long. But for an ordinary individual to serve a year in jail is a very significant period of time. Ms. Hiller was incarcerated for an extended period of time due to her parole, which again, she doesn't get credit for. But that didn't make things any easier for her in terms of gaining stability. That is, just like you said in the last sentencing, Your Honor, that only puts her further behind. And I'd like to think that once Ms. Hiller is done, that she'll get into treatment, which she had indicated that she's hopeful that she can get into treatment. She's been taking advantage of classes while she's been incarcerated. She's doing the things that she could do. At one point in time during the course of this case, she was trying to get into drug treatment, at which point I think the court had said, well, I might consider it as sentencing if you enter into a plea or you're otherwise convicted, or, you know, if there's some other remedy where that might be a possibility, but that's not the time currently. So now as we come to sentencing, Your Honor, I guess the larger question is whether it's the court will do is either A, or to file the recommendation and give her a county year, or B, is it going to send her to prison? And I guess if I look at it just from Mr. Ziegler's perspective, I could see where maybe arguably prison might be a possibility. On the other hand, if I look at it and I attempt to look at it objectively, she's done nothing wrong other than to further compound her own personal bad choices in life. And again, you know, using drugs doesn't help anyone, or at least that's my opinion. Whether or not everyone shares that opinion, I guess that doesn't matter. But she wasn't really hurting anyone other than herself, Your Honor. She's lost a lot of time due to her drug addiction, lack of coping mechanisms. And because she wants to get into treatment, I think that that's a helpful thing for her, because unlike certain people, she is going to come back to this community no matter what the court sentences. She has family here, she's from here, she's coming back, whether it's from prison return or whether she gets county time. And I just assume that she get the treatment that she needs, that she's always needed. And I guess, you know, in certain people's lives, and hopefully in Miss Hiller's life, which expressed to me that all the time that she spent incarcerated has never helped her further her objectives of becoming stable or having a good, meaningful life. It's always put her behind. And she acknowledges fault through the things that she's done. But she's now come to the realization, and maybe it's too little too late, but hopefully it's not, that she needs to change, and she wants to do that, which is probably more powerful than the court ordering somebody to get into treatment or engage in a specific program of some sort. So to that end, Your Honor, Ms. Hiller is just hopeful that the court will follow the recommendation. She accepts fault for what she's done, but again, Your Honor, she's still a young person. This is not like an assault type situation where she assaulted someone or victimized someone. This is a situation where, if anything, she's victimized herself and her family. You know, her attitude has changed significantly through the course of the case. Her having interacted with Jennifer quite a few times over the years, you know, she has been difficult at times, and she's struggled to accept responsibility for certain things. But in this moment, I think that she's had somewhat of a life change, and she's hopeful that she'll be able to turn the corner. And again, and I've already said this, a year in jail is a very substantial amount of time. And it really is. And whether it's 23 months or 12 months, any period of incarceration is meaningful. And I'm hopeful that when she comes out, she'll find meaningful employment. Hopeful that she'll maintain her sobriety, because she's been off drugs for a period of time. There's no reason for her to have a relapse now. She wants to get into treatment. Hopefully that will give her the tools to address her underlying problems she uses. She is sorry that she finds herself in this position. So I'm just asking the court to give her one final opportunity to follow the recommendation, which I do understand the points that Mr. Ziegler made, but unfortunately, Ms. Wagner is very familiar with Ms. Hiller as well. So about the need to make that recommendation.
Thank you, Ms. Hiller. Anything that you wanted to say?
Yes, I do. I have a letter I should read.
Okay.
I will say, some things the prosecution always point out right before they say they've exhausted all their resources when it comes to helping me overcome my flaws. Drug addict, menace to society, danger to the community, never earned an excessive record. Mother, daughter, student, sexual abuse and domestic violence survivor, loving, kind-hearted, and generous, is a side of me the court doesn't see or point out. On March 12th, 2024, I was released from prison. Not long after, I found myself in a downward spiral that I couldn't bring myself out of on my own. I felt like my life was a temptation with no escape, an obsession with no end, an addiction with no cure. Prior to my incarceration, I called Anna Marie and got myself funding to go to inpatient treatment. 2 days later, I was arrested for my current charges. During this time, I've been honest and forthcoming. I take full responsibility for my actions. I know and acknowledge that I have a serious drug addiction that I dream and desire to overcome. With over 200 days clean, I'm proud to say that I still call every week to reserve my spot in an intensive outpatient treatment in a girls' home in Petoskey through Bear River. I also attend all groups that the jail offers, including CMH. I sincerely apologize to any and everybody involved. Your Honor, I'm asking you please to allow me to continue what I've started. I know I deserve more jail time and I accept that. Please allow me to serve a jail sentence that allows me to go to treatment. And I also have all the certificates and letters and stuff from all the groups that I was attending while incarcerated. I have Catechumen Services and AANA, Healing Private Wounds, everything that I had earned to show that I was going to groups, and that just because I'm in jail doesn't mean I still don't want to continue what I started. I knew I had a problem prior to me getting arrested. I called and got myself treatment, but of course I had to wait on bedding and waiting for somebody to leave, or just, and then 2 days later I got arrested. But since I've been down, I thought I'd hit my rock bottom before, but this time I learned that my rock bottom had a basement. I lost my son. I lost everything. So I really would like the chance to attend this Bear River outpatient where they approved me for a tea house in Petoskey, where I have to do groups and meetings, and they help me with transportation for a job, and I have to pay a rent every month. It gives me the supervision kind of that I want to help progress and show me how to live an adult life, how to be the mother that I desire to be. I can't make excuses for why I use drugs. Things happened in the past, but I take the easy way out because that's my comfort zone. But I'm sick of taking the easy way out. I'm sick of not being able to call my child and talk to him, or my family saying, we're not going to make it if you go to prison again. Like I'm losing everything. I would just ask you, please allow me to stay in jail, not go back to prison, so I can do treatment and get the help that I really need.
Okay. All right. I did read through the report. I'm familiar with your circumstances. Generally, you've been in front of me before. So I'm familiar with what brings you before the court here today and kind of your past issues. I'm not really going to address your past record. I think Mr. Ziegler did a good job of outlining the problems that you've had. In terms of rehabilitation, you're only 28, right? So you're still really young, from my perspective, really young. You still have a lot of life ahead of you, and you still have a lot of opportunities to get things back on track. Your record, of course, is going to be something that follows you, and you're going to be battling that for the rest of your life. But in terms of rehabilitation, I'm always of the opinion that people can turn their lives around at any point, whether they're young or old or otherwise. So I think you certainly do have the potential for that. I think the real question for the court is that something that you should do on the people's time? In other words, while you're serving your punishment, or is it something that you need to do on your own? And when I look at your record, you were on probation 4 times as a juvenile, 5 times as an adult. That's 9 times on probation. That didn't correct your behavior. 10 jail sentences, that didn't do it. And of course, 3 prison sentences. So at this point, you've run out of chances for the court to give you opportunities to attend treatment during a sentence. Because at this point, I have no reason based on your past conduct to expect that you're going to do something different. And so I'm just not going to commit public resources to that because of the number of times that you've had a chance to do that. Now, that doesn't mean that you can't seek that on your own. And if you really want to make a change, that's eventually what you're gonna do. But I think Mr. Ziegler makes a really good case for what your punishment should be. I think based on your record, an argument could be made for exceeding the guidelines in this case. I think you benefited from a pretty good plea offer. Otherwise, you would have been looking at guidelines that didn't even allow for a local sanction. But at this point, based on your record, your performance while you were on parole, the court doesn't see any reason at this point to sentence you to a lesser sanction. So the court is going to sentence you to 23 months to Department of Corrections. Because of your parole status, you do have 0 days credit. The court is going to order a crime victim's assessment of $130, court costs of $325, attorney fees of $350, and $68 state costs. You do have the ability to seek an appeal of this sentence. Mr. Seeger, can you?
Your Honor, for the record, I'm giving her a copy of her apologize. Return a copy.
At this time, Ms. Hiller, you are remanded to the custody of the state. Our next hearing is set for 10 o'clock. We'll take a short recess until that time. We're ready with Mr. Way's case.
We are, yeah, Way's in the courtroom.
People versus Scott Way, file number 255002. If I could have counsel put your. Please.
Ryan Ziegler, on behalf of people, Your Honor.
Kyle Travis on behalf of Mr. Way.
Okay. Mr. Travis, can you tell me the status of this file?
Yes, Your Honor, we did waive the prelim in this file and have had some previous discussions. This is our first appearance. We would ask the court for a 30-day adjournment. We still want to keep talking about some things and investigating some things and basically continue the discussions.
Mr. Ziegler?
I have no objection, given that this is the first appearance. Sir.
I guess, Mr. Travis, what I'd like to do is set, a meaningful plea cutoff date. So I just want to avoid coming back in 30 days and then another adjournment, 30 days and another adjournment. So what do you think is a realistic amount of time here for your client to, and I understand these, given the nature of the charges here, that there's probably some pretty in-depth discussions going on. Can you give me a realistic timeline on when we're going to be ready with yes or no, please?
Your Honor, I think hopefully within 20 or 30 days, probably within. I think we'll have another point of linchpin, of plea discussions in probably 3-4 weeks. So probably within 2 weeks ahead of if we set it for the court's next day. So I think there's a reasonable likelihood that we come back in 30 days, we're going to know what we're doing. But you're right, given how complicated the case is, if that doesn't really change anything, there is a chance that maybe we want to talk more. But I think quite realistically, if things go as I have planned, which doesn't always happen, we would come back with either a change or no change in status.
Okay. All right. So the court will set this for a plea hearing status conference in 30 days. In the meantime, Mr. Way, it's important that you stay in touch with Mr. Travis, and when we're here for that next hearing, for you to have made a decision about whether you want to enter into any kind of plea agreement in this case, okay? Mr. Ziegler, anything further on behalf of the people?
No, Your Honor.
Mr. Travis, anything?
Nothing further. Thank you.
Do you have any questions at all, Mr. Way?
Just thank you for your time.
Okay, that's all for today. Versus Christina Petty, file number 255005. Reflect Ms. Petty's present in the courtroom. If I can have counsel put your appearances in.
Ryan Ziegler, on behalf of people, Your Honor.
Kyle Travis on behalf of Ms. Petty.
The status of this file today, Mr. Travis.
Yes, Your Honor. We did waive the prelim, and are very appreciative. Mr. Ziegler made an offer just at the end of last week, and Ms. Petty would like to accept that offer. My understanding of that offer is she would be pleading to an operating while intoxicated second, and that would resolve all counts.
Fair statement, Your Honor.
Trouble finding the information. Okay, Ms. Petty, have you had a chance to speak to Mr. Travis about this agreement?
Yes,
Okay, and is that how you wanted to proceed today?
yes, sir.
Raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Ms. Petty, are you currently on any kind of probation or parole?
Technically, yeah, I'm on bond and probation
Okay, where's your probation from?
here.
Okay.
District Court, Your Honor.
Oh, sorry.
Do you know, have you spoken to them about this plea today and whether that's going to violate your probation?
No, I emailed him, but he never responded.
Okay,
And it's not a definite, but I think she was given a 15-day violation when she was charged with this.
oh, okay, so that's already been
Yes.
addressed.
Yes,
this charge?
sorry, yes.
Okay.
Yeah.
All right. I just want to make sure, because I have to warn you about all the potential penalties, and that's one of them, so.
Okay,
All right, and then, the second offense, operating while intoxicated, you understand that that's a misdemeanor that's punishable by up to a year in jail.
yes,
With that in mind, what is your plea to that charge today?
guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt if you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want to. You understand that you have all of those rights right now.
Yes,
And you understand that you're going to be giving up and waiving all of those rights by pleading guilty.
yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No,
Has anyone promised you anything other than what we said here in court today?
no,
Is it your own free choice to enter this plea?
yes,
Are you pleading guilty because you are actually guilty?
yes,
This happened back on December 4th of 2024, is
Yeah.
that correct? Okay. On that date, had you been consuming alcohol?
yes,
And after you consumed alcohol on that date, did you operate a vehicle on South Cedar Street here in Kalkaska?
I did.
And did you have any blood or breath tests to determine the amount of alcohol in your system?
I had the breathalyzer on scene and then blood was drawn at the hospital because their breathalyzer at the jail was broken at that time.
Okay, and do you remember what the results of those tests were?
0.12, I don't know how that.
The blood's 0.214.
Was it above 0.08?
Yeah,
Okay. Had you consumed enough alcohol that day that it prevented you from being able to safely and normally operate that vehicle?
yes,
Had you previously been convicted in July of 2023 in the district court here of operating while impaired?
yes,
Mr. Ziegler, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Travis?
Yes, sir.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Travis?
No, you're not.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Yes, your honor.
Court finds, Ms. Petty, that your plea is knowing, voluntary, and accurate. Court is satisfied there's a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. This matter will be set for a sentencing hearing. You'll be notified of the date and time of that hearing. Make sure that you stay in touch with Mr. Travis prior to that day. And you're going to meet with Agent Bear up here before you leave court to set up a pre-sentence interview, okay?
okay, thank you, Your Honor.
Thank you.
Ryan, is that an added count 3?
Add count 3, that code is 257-625-6B is in boy.
Okay, great, thank you.
Are you ready on Mr. Canyers?
You just got here, just a minute.
Sure. Okay. Hearing, so let's just take a short recess. We'll come back. We're on the record in People versus Trepanier, case number 244891.
Brian Ziegler, on behalf of the Plea, Your Honor.
Kyle Travis on behalf of Richard Trepanier.
This is set for a status conference today, as well as a motion hearing. On your motion, Mr. Travis, to admit certain testimony regarding the complaining witnesses' prior sexual history and history of abortion. I did have a chance to review your motion as well as the tape of the interview with Mr. Trepanier. I did have a chance to review Mr. Ziegler's response. So, Mr. Travis, anything by way of oral argument that you wanted to present today?
Your Honor, largely I'd leave it to the written motions. I would just say in reviewing prosecution motions, the reason we want to admit it are the reasons that I've stated. It is a critical, particularly the abortion is a critical timeline in both the defendant and alleged victims' timing of things and discussions of things. I think it's a fairly critical element. Mr. Trepanier specifically references the admissions or things he's talking about occurred after the abortion in his mind. And so I know the prosecutor is concerned about other things it can be used for that is not the prosecutor or the defense's intent. It is because it interplays with critical timeline issues. And then relative to the other piece of her being sexually active, I think as I lay out in the motion, it is just, it would be quite damaging just to talk about the abortion, but not talk about, as is stated, that it is not necessarily Mr. Trepanier that's even alleged to have been the cause of that abortion. Thank you.
Mr. Ziegler?
You know, I think regardless of the intent of the defense, it's the type of testimony that's going to be particularly inflammatory to a jury, especially given the current political climate regarding the issue of abortion. I would say that perhaps the defense's arguments about timeline and recollections and all of that might have more merit, but for the fact that his client admitted on video that she was 15 at the time, and he says that multiple times on the interview. So to my eyes, any relevance of using the abortion or using whether or not she's sexually active as a yardstick to try and determine when this event would have occurred is kind of made moot or irrelevant by the fact that he's confessed that she was 15 at the time. And the court has looked at all of the video on that, so the court knows exactly what the issues are at play there. So I would just say, Your Honor, the relevance of that kind of testimony, given his admissions, is minimal or non-existent versus the prejudice where this is going to devolve into some discussions about when exactly did this abortion occur, who exactly caused the pregnancy, how sexually active was she at the time, who else might be the father. All of this stuff is highly inflammatory and leads the jury down a path that is completely irrelevant to the question at hand, which is whether or not they had a sexual encounter when she was 15 years of age, which he's admitted to. So I think regardless of whether the defense portrays it as their intention to inflame the jury or to confuse or mislead the jury or not, there is a very high danger that that is going to happen. So I think for those reasons, Your Honor, under 403, those mentions on the tape and any other evidence to that effect should be excluded.
Anything in response to that, Mr. Travis?
Your Honor, I guess I would, Mr. Ziegler wants to say that the statements that my client made are definitive, but I think that's exactly why this is crucial, because as Your Honor's watched the tape, almost with every admission, there is a corresponding, I don't remember, I don't recall it being that way. We're talking about events that happened so long ago. I think anything we can use to piece together the timeline is important and critical. And I would say even the alleged victim has given two different versions of when this occurred. So that's the importance of this, is the prosecution wants to say that Mr. Trepanier's statements are definitive. I would say, particularly watching the video in a fuller context, they're not. And that's why the abortion issue matters, because he's definitive in the video that this all happened after the abortion. our argument would be he was confused as to whether she was 15 or not because of the moving around of dates and times. Thank you.
All right, so again, I did review the briefs of the parties. I had a chance to review the case law that was cited, the rape shield statute. And so first of all, I guess I would say that based on strict interpretation of the rape shield statute, the issue of whether or not the complaining witness had an abortion in this case, I think is something that under the case law would be arguably admissible, all other things being equal. I think the court has to decline the people's invitation to not follow case law, precedential case law, and instead go with concurring opinions. Number one, I think that's a dangerous road for the court to follow. Number two, I don't think it's appropriate. So the court finds that arguably that kind of evidence would be admissible if it was otherwise relevant, and if it wasn't unduly prejudicial, would lead to a confusion of the issues, or would be cumulative under MRE 403. So I think where the rubber really hits the road in the court's analysis here is really as to MRE 403, because I think there's arguable relevance. I think it's arguably admissible under the rape shield statute. So then the question is its probative value outweighed by the potential prejudicial effect, danger of confusing the jury, and so forth, the typical reasons under MRE 403. And so the potential probative value here, as outlined by the defendant in their brief, as well as Mr. Travis here on the record today, is for the purpose of establishing this timeline, which is relevant to the extent that it bears on whether the complaining witness was under the age of 16 at the time of any alleged sexual contact between her and the defendant. And so what is the probative value as to the timeline of when this abortion took place, or the fact that there was an abortion? And then is that probative value outweighed by the prejudicial effect? And in my view, looking at the circumstances as a whole here, the probative value is low in relation to its potential prejudicial effect. Number one, as Mr. Ziegler indicated, I think there's, regardless of the current political climate, I don't think that is a good reason to either admit or not admit evidence under MRE 403, because that's the kind of thing that is fickle and may have more or less importance at any particular time. So the court's not relying on that. I think the nature of an abortion itself, regardless of the current political climate, has the potential for the jury to place undue weight on that kind of a thing. Again, regardless of the political climate, it is something that people have strong views about, and one way or the other, jurors may, again, place undue weight or view that as having more relevance to the ultimate outcome of this case than just as to the timeline. And I think even with some type of limiting instruction, I think it would be difficult for jurors to separate judgments about the abortion and judgments about the ultimate issue in this case, which is whether or not a sexual assault took place. And then looking at, its relevance to the timeline, one of the factors that the court looks at in terms of probative value is whether or not that is something that can be proven through other less prejudicial evidence. And in this case, the court finds that there are other ways to show the timeline, to argue either that it didn't occur when the complaining witness was under the age of 16, or she was mistaken about when it occurred, that are less prejudicial than evidence regarding the abortion. So for all those reasons, and in the exercise of the court's discretion, the court finds that evidence relating to the abortion, and then therefore the issue of whether or not, or the issue of evidence about prior sexual instances of complaining witness is still hand in hand. If the evidence relating to the abortion is not admissible, then certainly evidence of prior sexual conduct would not be admissible as it relates to the abortion. So again, for those reasons, the court is going to deny them a motion by the defendant to admit that evidence. And Mr. Ziegler, I would just ask that you prepare an order that reflects the ruling of the court today.
Yes, Your Honor.
Aside from that, we do have a status conference set for today. We do have a hard trial set to begin, I believe, on March 20th. Mr. Ziegler, are the people going to be prepared to go forward? The trial is scheduled.
Yes, Your Honor.
Mr. Travis.
Yes, I believe the defense will be ready, Your Honor. Given the ruling, I guess if maybe I can handle my other matters and then we can still come back to do the final so I can discuss with Mr. Trepanier what he wants to do.
Sure.
Thank you, Your Honor.
Okay, anything further that you want to address in this case for right now?
Not for right now, thank you.
Okay. All right. Are you ready on Mr. Willoughby's case?
We are, Your Honor.
Court will call People versus Willoughby. This is file number 244988. Records reflect Mr. Willoughby's present here in the courtroom today.
Yes, Your Honor. Kyle Travis on behalf of Mr. Willoughby.
Your Honor, Ryan Ziegler on behalf of the people.
This is the date and time set for sentencing in this matter. Mr. Willoughby, did you have adequate opportunity to go through the pre-sentence report and talk to Mr. Travis about?
Yes, sir.
Okay. Mr. Travis, are there any additions, deletions, or corrections to the report?
Yes, Your Honor. On the front page, and it says there is no objection to HIDA status. I discussed with Mr. Ziegler as both of our positions, the plea was with HIDA, no objection to HIDA. And then there is a scoring matter that we're in agreement on also.
Okay, what's the, well, first of all, as to the plea agreement terms, Mr. Ziegler.
It's accurate. The plea contemplated HIDA as part of the terms of the plea.
Oh, and then Mr. Travis, the scoring issue.
Yes, this gets into a matter relative to this case in the charging and the complaint. I don't want to speak too much for Mr. Ziegler, but I think when he charged the complaint, he didn't know the status of the weapon. So he charged it carrying concealed, which given that it's a BB gun, I think by my client's own admission, the carrying concealed wouldn't actually be supported. And we had already discussed that. It just never got taken off or amended. It was always kind of acknowledged once the facts came together. So then that would be relative to OV 12. It's scored at 10 points because of 3 contemporaneous felonies, and that would only be 2. And I spoke to Mr. Ziegler about this, and he agrees with that. And that would bring it down to 5 points. It actually does not affect the scoring guidelines, but it just is that. Obviously, Mr. Barrett was going by the felony information. It's just we had discussed that that charge couldn't really be supported.
Mr. Ziegler.
Your Honor, I would agree that ultimately the weapon was not actually sufficient to meet the definition of a firearm. So I think carrying concealed would not apply. So I would concur with Mr. Travis's analysis for 12.
Okay, so that reduces the OV points to 15, but doesn't change the level. Is that correct?
That is correct.
So the court will order that OV 12 be scored at 5 points and that the total OVs be scored as 15. Guidelines will remain 0 to 9. Any other corrections?
No other corrections, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Do people have any victims that wish to address the court today?
No, Your Honor.
Anything on behalf of the people for allocation?
Your Honor, the recommendation in this case is for 9 months jail. I can't agree with that recommendation in this case, although I do completely understand where that recommendation comes from. I think the conduct in this case is quite inexcusable. This is a case where 2 young men went to find someone they had the intention of assaulting. They had weapons that, for all intents and purposes, appeared to be Glock firearms, when in fact they were pellet guns of some variety. They were wearing ski masks. they went out and they assaulted this individual, including in Mr. Willoughby's case, striking him with that gun. And I've had a chance to handle the weapon. It is heavy in the same way that a real Glock handgun would be. It has some real weight to it. And I don't think anyone, even law enforcement, but for pulling out the magazine and taking a close look at it, could tell that it was not a real firearm. So the conduct in this case is quite egregious. He does not have an adult history. He's only 18 years of age, but he does have a juvenile history that does include an assaultive offense. So I completely understand where the recommendation comes from, but I think given that he is just 18 years of age, this is his first adult conviction. I fully believe that young people often make very, very poor choices in life. And that is the point behind the HIDA statute, is to give young people like Mr. Willoughby an opportunity while they are new to the criminal justice system on the adult side, to give them an opportunity to reform their behavior and hopefully correct this so it doesn't become a pattern of behavior. I don't think it's the right thing to do to send someone of his age and for a relatively low-level assaultive conviction to the maximum of incarceration. So I would ask the court to adopt the sentencing agreement that Mr. Travis and I entered into, give him an opportunity on HIDA probation. I think that will be more beneficial to him and more beneficial to the community. And I also believe that if the court feels some jail is appropriate, the court is certainly free to order jail as part of a HIDA sentence. That's what I would ask, Your Honor.
Thank you, Mr. Travis.
Thank you, Your Honor. Your Honor, we would largely agree with the prosecutor. We would ask the court to sentence Mr. Willoughby under HIDA. He is a young man. Obviously, we've all aware of his juvenile record. He is aware of his juvenile record. And even during the course of this, Mr. Willoughby struggled a bit, but of a very positive note is a lot of things that Mr. Willoughby talks to me about and is trying to do are good steps. There, it's not been perfect, but for an 18-year-old who wants to try and get on a better track with their life, he pursued going to rehab because he realized he had a drug problem. I think that's kind of an underlying thing here for a lot of his bad behaviors, that he was struggling or struggles with substance abuse. He's working on signing up for his GED classes. He's pursuing employment. So these are a lot of what we want to see an 18-year-old man do. We want to see him better himself. We want to see him deal with his problems. Now, unfortunately, he's had a lot of struggles with this. As indicated in here, he does not come from a stable environment. So he doesn't have, unlike a lot of 18-year-olds, parents he can go back and lean on who will give him the right situation. So he's struggled even in this short period where he's been out and not in a rehab and not in jail to do all the things that everybody wants him to do because of lack of stable housing, lack of funds. But he's there again, he's working on getting that fixed. He's working on getting employment. He's working on getting his GED, which will help him with employment. He's motivated to stay clean. He's talking to me about the right things. But I understand it is not a perfect situation, and he has not done perfectly even going forward. But I do genuinely think he wants to be a better adult. He's expressed that to me, and this is the things he talks about are, someone who doesn't have it all together, but is starting to think the right way. So I think HIDA is a chance for him to continue moving in the right way. Because he acknowledges where he came to up here was not the right way and not what he wants to do. Thank you, Your Honor.
All right. Anything you wanted to say, Mr. Willoughby?
Well, yeah. I understand my behavior was reckless. If the victims were here, I would like to apologize, but I can't. It's no excuse for what I did at all. It was reckless. It was reckless behavior. I've been able to possibly find employment with a job interview tomorrow. I have been 90 days sober, went to rehab, and even took myself out of the situation behind. The reason behind why I didn't complete was because there was drug usage in the facility. I didn't want to be around because I was going down the right path with not using. And You know, I've learned a lot of ways, even while being in the rehab for that short amount of time, to cope with myself, to cope with my emotions the correct way, and not in a negative way. And I'd also like to apologize to the court too, because this should have never happened. It wasn't, there's no excuse. It was not okay. And I'd like to apologize for that. Like I said, the victims were here. I would like to apologize to them too, but sadly I can't.
Okay, I did read through the report, familiar with what happened in this circumstance, and familiar with you and your background generally based on the information in that report. And I certainly take all of that into consideration along with what the attorneys said here. I do think HIDA is an appropriate mechanism here for probation. I do think probation is appropriate as well, even though it wasn't recommended. I think that some supervision and oversight for you is a good thing to make sure that you're staying on the right track. And to hold you accountable for your behavior over a period of time. This, to me, I mean, this sounds like a really stupid stunt that a bunch of kids came up with as a way to mess with somebody else that they didn't like or had problems with, and it's really ill-conceived right from the beginning. And I think the court has an interest in punishing that kind of conduct as well. I think, you know, some jail time up front with some held in abeyance and probation is going to, again, provide for that oversight and provide for a degree of punishment for you. And hopefully some motivation for you also to comply with probation. So the court is going to order 24 months of probation pursuant to HIDA. The court's going to adopt as the conditions of the probation all the standard terms and conditions that it would normally order. In addition, the court is going to order that there be no contact with, I think it was Mr. Hermstein, is that right?
That's right.
Okay, I want to include that as a condition of the probation. The court is going to order that you serve 9 months in the Kalkaska County Jail. You do have credit for 49 days served. The court's going to order that you serve 3 months of that up front. The court will hold the remaining time in abeyance to be served at the discretion of the court. So if you do violate your probation, Mr. Willoughby will have to serve the rest of that time.
Yes.
The court is going to order a crime victims assessment in the amount of $130, court costs of $325, attorney fees of $350, a DNA testing fee of $60, and a $68 state cost. Because the sentence is pursuant to HIDA, there are no written appellate rights at this time. Mr. Ziegler, is there anything else that we need to address?
Nothing for the owner, thank you.
Mr. Willoughby, you are remanded to the custody of the county. And we're going to take a brief recess. The court will come back on the record. Let's go on the record in People versus Matthews, page number 244978. Matthews, I'm gonna have you go right to the podium there, please. If I can have counsel put your appearances on.
Your Honor, Ryan Ziegler.
Good morning, Honor. Matthews for Brandon Davis, P74251 on behalf of the defendant.
Thank you. This is the date and time set for sentencing in this matter. The record should reflect Mr. Matthews is present here in the courtroom today. Mr. Matthews, did you have an adequate opportunity to go through the pre-sentence report and talk to your attorney about that? Okay. And Mr. Davis, just to let you know, I did receive a number of support letters on behalf of Mr. Matthews. I did have a chance to review all of those prior to the hearing today. Do you have any additions, deletions, or corrections to the pre-sentence report? Do you have any challenges to the scoring of the guidelines?
I do not.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
There you go.
Any challenges to the scoring?
There you go.
Anything on behalf of the people for allocution?
Defendant before the court today for a significant role in bringing a large quantity of controlled substances into our community. The defendant was in a residence right here in the village of Kalkaska when Traverse Narcotics Team, or TNT, executed a search warrant. He was caught with 59 grams of meth and 32.5 grams of fentanyl strapped to his leg. He was in a room in the drug house with another young man from Muskegon, Jaleel Donson, who had the vast majority of TNT's buy money in his pocket. The house contained significant amounts of controlled substances and was being used as a front for the illegal distribution of narcotics. Matthews, Donson, and a third juvenile, Jamal Hansen, were bringing the drugs up from Muskegon and selling them to persons at the house, namely Joshua Ayers and Tayana Cloud. Ayers and Cloud were then further distributing them, as evidenced by their recent pleas and sentences. All of this backstory, Your Honor, is to make 2 points. First and foremost, the defendant played a major role in bringing these drugs up from Muskegon and into the area. He had the drugs and he was the only adult among the three from Muskegon. Second, it is clear that he and his associates were more culpable than Ayers and Cloud, as he appears to have been a supplier for them. Well, he has no criminal record, he's relatively young, and he's likely capable of rehabilitation. The guidelines are 24 to 40 months, and I think with good reason. I do not need to explain to the court the dangers to the community of significant amounts of controlled substances at issue in this case, particularly the fentanyl, Your Honor. 2 to 3 milligrams of fentanyl can be fatal. The defendant, therefore, by my math, had approximately 13,000 lethal doses of fentanyl strapped to his leg. The court has seen in this county and in other counties where the court presides what can happen when even an experienced drug user takes a controlled substance thinking that it's meth or heroin, and that it turns out later to be fentanyl. Fentanyl is a danger to our community, full stop, and those who are bringing it up in large quantities must be punished severely to deter that conduct in the future. The guidelines are 24 to 40. I don't believe the defendant is deserving of the highest end of those guidelines, given his young age and given his lack of record. I also don't believe he's deserving of the lowest end of those guidelines, Your Honor, just given the significant amount of drugs that are involved in this case and the danger they represent. I think 32 months is exactly in the middle of the guidelines range. I think it's an adequate, appropriate sentence. It reasonably balances the mitigating factors that the defendant presents with, as well as the seriousness of his conduct. So I would ask the court to sentence the defendant to 32 months in the Michigan Department of Corrections.
Thank you. Mr. Davis, anything on behalf of your client?
Yes, thank you, Your Honor. I'll start with this. I had the opportunity to sit on the last sentence that this court heard and listen to the allocution of counsel. My comments today will be largely aligned with the remarks that were made by the prosecutor, because the defendant, my client, stands in a similar position, although he has no criminal record at all. My client comes before the court today taking full responsibility for his actions. My client recognizes the significant position he's both placed himself in, placed community in, and placed his family in, who are here today supporting him. I oftentimes when we come to sentence, and I spent a big part of my career as a prosecutor, so I understand comments made by counsel. But oftentimes when we come to sentencing, we talk about one day. Talk about one day in the life of an individual. And it's often the argument that a defendant should be sentenced based off of that one day. I submit to the court that whereas the court must consider punishment, the court must consider deterrence, the court should also consider rehabilitation and consider more than this one day in my client's life and in the life of this community, but consider the life that he's led before and after that day. The court received numerous letters of reference and support that speak to the character of my client. Every person that I've had contact with that's wanted to give a letter of support for my client has been completely shocked because this does not align with the person that he is or the person that the life that he's lived. My client is well supported by his family. He's respected in community before and after this incident. He was employed, Your Honor. He continues up to today to be employed. He's also taken additional steps to take a drug-related class, and a certification was submitted to the court related to that. He was admitted he's a high school graduate and has been admitted into college and also into a trade program to continue his education. He stands at a turning point, Your Honor. We're at a turning point in the life of this young man, a place where it can say we throw him away, or a place that we say we want to push him in the right direction in order to continue to move forward and learn from this serious, not mistake, choice. It was a choice that he made, a choice that he understands was wrong. One of the things the prosecutor said that I do take issue with is that my client had a significant role. There were a lot of assumptions made in the argument that was made by counsel. What we do know what my client pled to was having drugs taped to his leg. That's what he pled to. Whether there was him being significantly involved in some other way, there's no evidence to support that. Him being a leader in the home or anything like that, there's no evidence to support that. And I submit that that's not true. And what do we have to look at when the court's making these determinations? Well, if we look at my client's record, my client stands before the court with no criminal convictions, no juvenile convictions. This is his first, as we normally would say, brush with the law. It's serious. I don't want to minimize what occurred, and that's not my goal here. But I think it's important to take into account who and what he is, where he stands. He came from a community where it was more common, but he understands that this is not okay. He understands and does not want to live this life and has never led this life. And that's why it's the court could see in the letters was so shocking to everybody. This is not the young man that we've come to know. This young man was a student of my wife. And when she heard of it, the look of shock on her face was next level. Why? Because this is not who he is. He finds himself in this position. Obviously, he stands before the court, but he asks for mercy. Your Honor, when I look at this case, the Home Youthful Training Act is designed for youthful offenders. The prosecutor discussed my client as an adult, and legally he is an adult, a 19-year-old. But I don't even believe he was 19 at the time of this offense yet, but he is an adult. He stands before the court as a 19-year-old, who made a wrong choice, who we still have the opportunity to turn his life around. We still have the opportunity to make sure that all of that is not thrown away. I'm asking the court to sentence the defendant under the Home Youthful Training Act because the Home Youthful Training Act is available for youthful offenders. It doesn't even require that it's your.
Well, let me ask you about that because my understanding is you're not eligible if you've been convicted of a major controlled substance offense. And I believe that the delivery or manufacture of methamphetamine is considered a major controlled substance offense.
Yeah, my understanding of the Home Youthful Training Act, and I have seen this apply to delivery of methamphetamine previously. I didn't anticipate the court asking. I can pull it up if the court wants to go off the record or something like that if it's necessary. But I am asking for treatment under the Home Youthful Training Act. I believe the defendant is eligible for treatment under the Home Youthful Training Act based on the fact that he meets both the age requirements and this does not fall into the category of a life offense or anything like that, which would, based on my understanding, prevent him from being eligible. The court does not sentence him under HIDA. I am asking the court to go beneath the guidelines, taking into account his lack of a criminal record. If we look at the scoring in this case, the scoring is 0 points everywhere, except for when it comes to the weight of the narcotics. And I'm not arguing the weight in this case, because I understand that the OB connected to that does talk about a mixture. It can be a mixture, although we recognize that the way the drugs are tested is usually not the full amount. With all of those things being said, Your Honor, I'm asking the court to have mercy recognizing that punishment is necessary, but we do have a young man that's standing before you, not only who's remorseful, but who was doing all of the other right things, made a bad choice, but outside of that is doing all of the right things. And I'd ask the court to take that into account. Thank you.
Okay. Mr. Matthews, anything that you wanted to say?
Yes, sir, Your Honor. Your Honor, I'm writing this I am writing this to express my deepest remorse for my actions that led to the charges against me. I fully understand the seriousness of my crime. I take full responsibility for my actions, and I am truly sorry for the pain and suffering I have inflicted. My behavior was unacceptable, and I understand that I have been reflecting. I understand that, and I have been reflecting on the reasons behind my actions. Since this incident, I've been going back to school for college and HVAC programs. I am committed to making positive changes in my life and ensuring that this will never happen again. If given a second chance, I will continue to move forward, make better life choices, seeing how my actions affect not only me, but others around me. I made a mistake, and I humbly request your consideration and forgiveness as I work towards becoming a productive member of society.
All right, thank you. Davis, I'm gonna go off the record for just a minute to double check HIDA. I did have a chance to review the HIDA statute, and I do not believe that delivery or manufacture of methamphetamine is a controlled substance, a major controlled substance offense within the meaning of the statute. So I believe Mr. Matthews would be eligible. However, of course, it's within the discretion of the court whether or not to order that. But I do want to make sure the record is clear that he is not prohibited or ineligible for HIDA. So first of all, Mr. Matthews, I did have a chance to review the pre-sentence report, so I'm familiar with the circumstances that bring you before the court today. I'm familiar with your background and your circumstances as well, based on the information contained within that report. As I said, I read the support letters that were submitted on your behalf, and I take all of that into account along with what you've had to say here today and what the lawyers have had to say. There's a couple things that stick out to me about this case. Number one, your age. You are a young man. The court certainly recognizes that people, and I think the legislature in general recognizes that young people are prone to making mistakes and engaging in behavior that as mature adults, they may have the foresight and the maturity to make different choices. So your age is certainly a consideration in what the court views as an appropriate sentence in this case. In addition to that, the letters that were submitted certainly paint a different picture to the court of you as a person than the information in the pre-sentence report does. And, I'm satisfied based on those letters that you do have good qualities that other people do see in you. And that, to me, is a factor that should be weighed towards finding that rehabilitation is certainly something that should be contemplated for you. So those are what I would call mitigating factors, or things that work in your favor here. And the court is bound to consider those, and I do. There are factors on the other side of the equation here as well. Certainly the amount of substances that you had on you personally and were around during this circumstance is shocking to me. I preside over many delivery cases and possession cases. Very rarely do I see the kind of amounts that were present here. Again, just in that household, but on you individually. That's concerning to me. I think it's interesting that the prosecutor did that calculation, because I did that exact calculation with regard to the fentanyl, because to me, that's a staggering amount of fentanyl. Bringing that number of doses into this community, I have no doubt that someone would have overdosed and potentially died had you been successful in delivering those drugs. And again, the fentanyl, it takes very little amount. 2 milligrams can be a fatal dose, and you had 30-some thousand milligrams on you personally, and that's not counting the other amounts. That is a very serious public safety issue, and the court has concerns regarding your conduct. And I think the story would be much different if you were here today on a delivery causing death charge, and I was listening to a victim who lost a loved one because of the fentanyl that you brought to this community. So this is a very serious offense. I am not convinced that this was a one-day thing for you. I don't think people get involved in these kind of amounts on a one-time basis. And I think you were fully aware of what was going on and what you were involved in, again, just based on the amounts. I just don't believe this was a random trip up north and you just happened to be holding that amount of substances on one day. So I don't believe that this is just one bad day that you had. I believe that you were engaged in the course of conduct of delivering, in the case of fentanyl, what is a very dangerous substance. And that's to say nothing of the methamphetamine, which is also an extremely dangerous substance. A typical street dose of methamphetamine is 0.2 to 0.4 grams. And you had 59 grams on you personally. So again, a large amount of drugs that you were bringing into this community. And so those are, to me, very serious components of this that weigh against those mitigating factors that I mentioned. Your involvement in this, because of the amount of drugs, because of the potential lethality of the drugs that you were bringing, certainly is not a reason for the court to depart downward. If anything, it would be a reason for the court to depart upward. So I don't find any justification for the court going below the guidelines here. Also, again, because of the amounts and the lethality, I don't find that HIDA is appropriate. I think a prison sentence is warranted in this case based on your behavior and the choices that you made. Unfortunately, sometimes even when you're young, certain choices carry with them more serious consequences than others, and this is one of those times. So the court finds that a sentence within the guidelines is appropriate. The guidelines are 24 to 40 months. The court finds that a sentence of 28 months is an appropriate sentence to account for your conduct in this case and the seriousness of the substances and amounts that we're bringing into the community. So the court is going to sentence you to 28 months to 20 years in the Michigan Department of Corrections. You do have credit for 3 days served. The court will order that you pay a crime victims assessment in the amount of $130, court costs of $325, $68 state cost, and a DNA testing fee of $60. You have the ability to appeal this sentence. The officer is going to provide you with Mr. Matthew's appellate rights. If you can please review those and have them acknowledge receive those. Mr. Davis, while he's doing that, just for the record, the court is going to attach those letters to the PSI so that they follow. Thank you.
Oh, just a minute. Okay.
You are remanded to the custody of the state at this time.
Talk to you soon.
Mr. Jarbo present.
Your Honor, Lauren File here on Mr. Jarbo's behalf.
Ms. File, if you'll come forward, please. Ma'am, are you Janna Shuart?
She is, Your Honor.
Nope,
Okay.
I'm Ann Weaver.
I'm sorry, what's that?
Ann Weaver.
Ms. Weaver, okay. Let me take this case real quick. Mr. Travis, you ready on Ms. Weaver's case? The court will go on the record in People versus Weaver, file number 244983. The record should reflect Ms. Weaver is present today by video from Wexford County Jail. If I can have counsel put your appearances on.
Brian Ziegler on behalf of the people.
Kyle Travis on behalf of Mrs. Weaver, Your Honor.
Mr. Travis, how did we want to proceed on this file today?
Your Honor, the defense would be asking for a 30-day adjournment. We have adjourned this in the past. Last time we were able to provide Mr. Ziegler with some documentation supporting that the loan that Ms. Weaver and her husband are pursuing to pay the restitution off is in progress. I did speak with Mr. Weaver at the end of last week, and he indicated he had some phone calls to the loan processor. They were basically telling him it was coming, but the money had not been released yet. So that is still our plan. Our goal is to pay the restitution and plead to a misdemeanor, but we do not have the money in hand today.
Okay. Any objection? That's
Plea is for a misdemeanor that's contingent on the fact that restitution is in hand. I would actually have that money prior to us going to a plea and sentencing. can be accomplished in the next 30 days.
What's your view on that? I mean, what's the timeline here?
Well, I believe, at least in speaking to Mr. Weaver, that he believes that that's when the money will come through. Mrs. Weaver, I think when we spoke yesterday, she's obviously incarcerated, so she doesn't have the most direct access to the money, but she seemed to believe that at the latest that the money would come through the 20th of this month, given some other information she'd gotten, but I can't confirm any of that. I did confirm and did get documentation that the loan is in process, it's happening. So I am optimistic that by the end of the month that the funds will be available.
Okay. All right, the court will set this for a plea hearing. Did you want to say something, Ms. Weaver?
Yes, sir. The loan is right now in the underwriters, which we sent Mr. Travis the documentation of that yesterday and all the correspondence between the processor and my husband, which being in the underwriter right now, the appraiser is coming back tomorrow because there was a mudroom that was left out. So it shouldn't be more than 14 days for that check to be gone through. But Your Honor, the check is coming in both of our names. And I'm gonna have to be out to sign this check, to put it in the bank, and to be able to withdraw the money. My mother is on my bank account, but she's not allowed to withdraw money. My bank told me that. There's no way I'm going to be able to do this still being in incarceration. So if I can't get a PR bond today, I probably would go with the plea bargain, to be honest with you, because I know this money will be here by the end of the month. But if I am not out, I can't sign the check. I can't do the footwork that needs to be done to have this finalized in a timely manner. I'm tired of wasting my time and the court's time.
How long have you been incarcerated?
This is 5 months, sir.
Misdemeanor that would be the subject of plea agreement in this case.
The misdemeanor version, embezzlement from a vulnerable adult, so 200 to 1,000.
Is that a 1 year?
Yes, Your Honor.
All right.
And Your Honor, I do believe she is accurate. I think as I was just starting to pull the file to figure out exactly when she came in. And Mrs. Weaver, one, she provided me with information. I did not get that email. But I have talked with her and her husband. And we were going to address bond because obviously that would make things helpful. But she has been, I think, Ms. Weaver, it was prior to the prelim, prior to this case being a bond over, she was incarcerated.
Ziegler, are the people that opposing any type of modification of bond at this point?
I am, Your Honor.
Okay. What's your reason?
Your Honor, this case began, she was arraigned back in July of 2024. A $50,000 cash or surety bond was set. The amount at issue in this case in terms of the embezzlement was somewhere in the area of $50,000 to $60,000. She bonded out at some point. In fact, the bond was lowered to $25,000 at some point. She posted that, she bonded out. She then tested positive for cocaine multiple times. I don't recall whether it was this court or whether it was the district court. I think it was the district court, revoked her bond in October, set the bond again at $100,000 cash or surety. She's been incarcerated since then. I'm certainly gratified to hear that we have some documentation of the mortgage in process. But given the fact that the charge relates to embezzling significant amounts of money, I would oppose any reduction in bond unless and until we have the check in hand. I don't understand the argument that she needs to be released on a PR bond in order to sign a document. Certainly that document could be brought to the jail. If a notary needs to be there, some notary can be brought to the jail. So the argument that this can't be accomplished while she's incarcerated simply is not a good reason for her release, Your Honor.
Yeah, so I agree with you on that. My point more would be that if she ends up pleading to a 1 year misdemeanor, she's already accumulated 5 months of credit.
That's correct.
Okay. Anything else you wanted to say, Mr. Travis?
Yes, Your Honor, and I would note even Granted, I realize there are bond issues. Even if it were to a felony plea, she's been incarcerated for quite some time. I would ask the court to consider releasing her in PR bond. And I do understand it may be able to be accomplished through people going through the jail, but I do get Mrs. Weaver's point. Her husband is down based practically in Indiana, at the bottom of the state. She's lodged in Wexford currently. And I suspect the prosecutor is not going to want to check from Mrs. Weaver, so she's going to need to produce some sort of cashier's check or something. So the whole thing is going to be a little bit more complicated than her just signing a release or something of that nature. So I do think it would, I understand it may not be an absolute bar, but I do think it would facilitate things if she was out. And largely, I would mostly point to Your Honor's point. She's been in there for 5 months. We're very much looking to resolve this with a misdemeanor. That's the goal of everything. And I think that's thank you.
All right, so number one, the court recognizes that this is likely to resolve in a misdemeanor plea. I'm satisfied, and I'm not hearing the prosecutor make any real argument that this loan isn't in progress, and that ultimately the defendant and her family have been diligent in trying to get this taken care of so that the plea is available to her. She's already served a significant amount of time in relation to the maximum possible penalty of misdemeanor in this case. The prior violations of bond, well, certainly the court takes any violation of the bond seriously. It wasn't a violation of, Miss Weaver not appearing for court or absconding. So the court doesn't have concerns, for public safety necessarily, or that Miss Weaver isn't going to appear for court or follow through with the financial aspect of this. So given all those factors together, I don't think the fact that maybe this could be accomplished with her still lodged is reason enough to deny bond at this point under all the circumstances. So the court is going to grant a $5,000 PR bond. Mr. Travis, I'll ask that, or is that something, can you do that?
Yeah.
Okay, so we'll have that bond paperwork prepared today. The court will set this for a plea hearing in 30 days. Ms. Weaver, if for some reason you don't appear for that hearing or we're not ready to go forward, the court's likely to revoke your bond, and if you're not here, to issue a bench warrant for your arrest. Do you understand that?
Absolutely do, and I will be there with cash in hand.
Mr. Ziegler, anything further on this file today?
There you go.
Mr. Travis?
Nothing further, thank you.
Okay, so Ms. Weaver, the court will process that bond paperwork today, and then make sure that you stay in touch with your attorney before the next hearing.
Absolutely. Thank you so much and have a wonderful day.
The court's going to disconnect from Wexford at this time.
Okay.
People versus Shuart, case number 244936.
Good morning, Your Honor. Lauren File here on behalf of the defendant, Janna Shuart.
Right, so right, yes, we need to are.
Yeah.
Just 1 second.
Sure.
While we're waiting, this is the date and time set for sentencing in this matter. Ms. Shuart, did you have a chance to go through the pre-sentence report with your attorney?
Yes, I did.
Ms. File, are there any additions, deletions, or corrections to that?
No, Your Honor, we would echo the pre-sentence investigation report that Ms.
Well, we'll do allocution in a second. You don't have any corrections to the
None.
report, any challenges to the scoring?
None.
Mr. Ziegler, do people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Do you have any victims that wish to address the court today?
No, Your Honor.
Anything by way of allocution?
Your Honor, I support the recommendations contained in the report. This was a case where Ms. Shuart was given the benefit of a delayed sentence. Her restitution was paid up front. I don't believe she's had any real issues during the terms of her delay. I think she's earned the benefit that she bargained for. And so for those reasons, Your Honor, I'd ask the court to adopt the recommendations, order that her conviction be dismissed.
Thank you. Ms. File.
Your Honor, I also would echo the recommendations in the PSI. There's been no issues while Ms. Shuart has been on probation. She very quickly paid the $4,210 in restitution. This is someone that has no criminal history. She's 63 years old. She made one bad choice. And I'm very thankful that these programs exist to allow people like Ms. Shuart a second chance to maintain a clean record. And I know Ms. Shuart is very thankful that she was given this opportunity as well.
Okay, anything you wanted to say?
Yes, I'm very thankful that I have this opportunity and also to show that I am a good citizen.
All right, I did review the original report just in preparation for the hearing today. And of course, the updated report that was prepared reflecting that the delay was complied with, which is, you know, anytime I think the prosecutor offers this kind of option and the court agrees to it, the hope is that it's going to wind up the way this has, which is full compliance. And so I see no reason to offer or sanction the agreement that you entered into. You did fully comply. And so the court will order that that charge be dismissed as indicated by the plea agreement in this case, and that you be discharged from the delay of sentence successfully. Let's file anything else that you need to.
Nothing, thank you, Your Honor.
No, Your Honor.
Thank you, Ms. Shuart. Good luck
Thank you.
going forward.
Thank you too.
People versus Aaron Johnson, case number 244985.
Morning, Your Honor. William Barnett from Cadillac on behalf of Ms. Johnson.
Thank you. The record should reflect Ms. Johnson's present here in the courtroom today. Mr. Barnett, can you tell me the status of this file?
Yes, I will, Your Honor. Ms. Johnson is in the process of being finalized as a sobriety court candidate in Wexford County. They have to have one meeting on March 14th. It's highly likely she'll be accepted. It's looking good. We're here for a final pretrial. We've had 1 30-day adjournment to allow that to happen. The court was uncomfortable, at least in writing, when you signed the stip to not adjourn it again. We're here to do one of two things today. We can enter a plea conditionally upon her acceptance to resolve the adjudication. It would be conditional upon her acceptance. Or we could adjourn for a month and have it taken care of post March 14th. But it does look like she's being admitted and that it's just a formality of running it by Wexford. The new judge down there is open to this. The prosecutor is from this part here and the Supreme Court gal who's coming in and doing other time. Has been meeting with my client and it looks like it's good to know. So it's up to the court. We have an advice of rights and prepared to enter a plea today to resolve it conditionally upon the acceptance of sobriety court and upon the successful completion of 5-year withdrawal down to a second offense. Mr. Ziegler?
That's all accurate, Your Honor, and I don't take a position as to whether we take a plea today or whether we give a 30-day adjournment. Based on what I've discussed with the sobriety court case manager, I haven't heard any issues so far. I've provided the referral. It sounds like it's what.
All right, my main concern usually with taking a plea before I by sobriety court is that we have to, you know, obviously later. It sounds like everything's in place, so I think it would be prudent to go ahead and take the plea while we're here today so that you guys haven't wasted the trip. That'll shorten everything by at least a month. So Johnson, and Mr. Barnett, for the record, again, the plea would be one is charged with upon successful complete, or reduction of that charge upon successful completion of sobriety court, correct?
Yes, Your Honor.
That's correct, Your Honor.
Counts 2 and 3 would be dismissed.
Correct.
Okay, so Ms. Johnson, have you had an adequate opportunity to talk to Mr. Barnett about this agreement?
Yes, sir.
Okay, and is that how you wanted to proceed?
Yes, sir.
You raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay. Ms. Johnson, are you currently on any kind of probation or parole?
I am not.
Okay. And you understand that, you know, if you were to not successfully complete the sobriety court program or violate your probation in some way, that you would be subject to the maximum possible penalty of the charge at count 1, which is operating while intoxicated third offense, which is up to 5 years and or a $5,000 fine. Do you understand that?
Yes, sir.
With that in mind, what is your plea to that charge today?
Guilty.
Okay. You understand that right now you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. You understand all those rights?
Yes, sir.
And you understand that you're giving up and waiving all of those rights by pleading guilty?
Yes, sir.
Has anybody threatened you with anything to get you to plead guilty? Has anyone promised you anything other than what we said here in court today?
No.
Is it your own free choice to enter this plea? Are you pleading guilty because you are actually guilty?
Yes.
Happened back on October 9th. On that date, had you been consuming alcohol?
Yes.
And after consuming alcohol, did you operate a motor vehicle in the area of the Burger King restaurant here in Kalkaska? Okay. Did you have any blood or breath tests to determine the level of alcohol in your system?
Yes.
Remember what that was?
I believe it was 0.35.
Was it was above a 0.08?
Yes.
Okay. Do you have any reason to doubt the accuracy of that test or those tests?
No, Your
Had you, in your own opinion, consumed enough alcohol on that day that it prevented you from safely and normally operating the vehicle?
Yes.
Had you previously been convicted of operating while intoxicated in 2023 in the district court here in Kalkaska?
Yes.
And also in 2020 in the 8th district court?
Sure.
Okay. Mr. Ziegler, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Barnett?
Yes, Your Honor.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Barnett?
No, Your Honor.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Barnett?
Yes, Your Honor.
Ms. Johnson, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there's a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea conditionally upon or based on your acceptance in the sobriety court program. If for some reason that falls through or doesn't happen, you'll be able to withdraw your plea and we'll go back to the program. Mr. Barnett, anything further that I need to address today?
No, Your Honor.
No, Your Honor.
So the only other thing, Ms. Johnson, is you're going to meet with Agent Bear up here before you leave to set up a time for a pre-sentence interview. Make sure you follow through with that, as well as anything that's required by the sobriety court program. And of course, make sure you stay in touch with Mr. Barnett prior to the sentencing date, okay?
Yes, Your Honor.
Thank you.
Thank you very much, Your Honor.
Mr. Horowitz. I think we have Mr. English connected here. Sir, are you Michael English? Sir, are you able to hear me? Mr. English, are you able to hear me okay? Mr. English, are you able to hear me? Mr. English, are you able to hear me? See us. Do we have any, Mr. Ziegler, did you get any kind of confirmation from?
I did, Your Honor. That is the correct facility.
Okay. Now they just disconnected. So let's just hold on a second. Maybe they'll reconnect here. Mr. English, are you able to hear us?
Doc, got you. Yeah. Yes.
Can you hear me okay?
Yeah.
Okay, all right, great. So we're on the record now in People versus Michael English. This is file number 24923 and I'm sorry, 244923, 244925. The record should reflect Mr. English is present today by video from Department of Corrections. If I can have counsel put your appearances on.
Ryan Ziegler, on behalf of
Michael Horowitz for the defense. Mr. Horowitz, can you give me a status of these two files today, please?
So as to the fleeing and eluding case, I believe that the court should schedule a trial on that. I've had difficulty in communicating with Mr. English while he's in custody because of issues with, I believe, the MDOC phone system and interfacing with my phone, although I think it's now resolved, so he can call. Mr. English has sent me by mail to file a 180-day notice. Also kind of tangentially at one of the concerns Mr. English has is about the contact with his children. I know that we had a hearing on that recently where the court accepted the party's stipulation. I don't know that I've seen an order distributed. But
I did sign an order.
yeah, I believe you did. I think I just haven't seen it. So I can.
Yeah, I did sign it on January 29th.
So I'll just ask for a copy of that at the clerk's when I get over there, because he just needs it provided to his NA case. But yeah, so I don't know what the next things would have been. Probably easier today had Mr. English been here in person, so we could have discussed. And I'm kind of shooting from the hip. As to the other case, indecent exposure case, I think that's just essentially trailing the.
All right, Mr. Ziegler, in terms of the trial, is there one file that you're gonna ask to be tried first, as opposed to a different one? They're both about the same time, looking at the offense dates.
Your Honor, I don't have a strong preference one way or another. I know the aggravated indecent exposure occurred earlier in time, so it would be my intention to hold that one first, just based on this.
Okay. Mr. Horowitz, you take any position on that?
I don't, I don't remember where I got the notion, but I had been operating under the assumption that the fleeing and eluding was going first, but I don't think that it would make much of a difference either way. Just, that was a major source of discussion for the most part of the case, I believe.
All right, so looking at the offense dates, file number 244925, which is the indecent exposure file, did occur earliest in time, so the court will set that first for trial. Mr. Ziegler, how many days of trial do you think?
I think that could be there, Your Honor.
Mr. Horowitz? Okay, so I'm going to set that for a trial. Can you be ready in 90 days?
Yes, sir.
Mr. Horowitz? So we'll set that for a jury trial, for a one-day jury trial about 90 days out. The court will set it for a final status conference, which will be the plea and motion cutoff on the motion day immediately prior to the trial date. Mr. Ziegler, once the court sends out the trial date, I'll ask that you prepare a writ so that Mr. English is transported for purposes of trial. Mr. Horowitz, will you be able to arrange for proper attire for Mr. English at the trial date? Okay. Mr. Ziegler, any other scheduling matters that we can address today? And the court will set the other file for trial once we get through the first one. Anything further from the prosecutor?
No, Your
Honor. Mr. Horowitz?
There you go, thank you.
Mr. English, do you have any questions about how we're going to proceed?
There shouldn't be no proceedings. Like if my attorney does what he's supposed to do, this should be dismissed. You guys violated my rights of 180-day policy to speedy trial. MCL 6.004.
And you are going to address that, Mr. Horowitz?
Certainly.
Yeah, so Mr. Horowitz is going to file a motion related to that. If the court grants the motion, then the charges will be dismissed. If it doesn't, then we'll proceed to trial. Okay?
All right.
Okay. All right, thank you. That's all for this hearing today. The court's going to disconnect. Okay. Travis, the court calls People versus Brandy Brer, file number 255018.
Ryan Ziegler on behalf of Bidri.
Kyle Travis on behalf of Mrs. Brister.
Docket, what are we addressing here today?
Your Honor, today is our first appearance in circuit court for Mrs. Brister. She's facing a charge of possession of methamphetamine. We've had some plea discussions with the prosecutor, and we waived the prelim based on those plea discussions. There's a couple, two issues that are not outside of the norm, but not always here. The plea would be to a 4-year possession of narcotics. It would also include that if called upon as part of the plea, Ms. Brister is agreeing to testify truthfully. And it would also indicate, or the prosecutor has also indicated as part of pleading in this, there would be no other charges stemming from any of the other activities alleged in the report that weren't charged.
One second. Okay, go ahead. I'm sorry. Anything further? on that?
No, Your Honor, just the quarter possession of narcotics with the two caveats of testifying truthfully and that there would be no charges from any of the other issues raised in the report.
Is that a correct statement of the plea offer?
It is, Your Honor.
Ms. Brister, did you want to accept that plea today?
Yes, sir.
Okay. You raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hand. Ms. Brister, are you currently on any kind of probation or parole?
No, sir.
And you understand that by pleading guilty to this added count 2, the maximum penalty you could face would be up to 4 years.
Yes, sir.
With that in mind, what is your plea to that charge today? Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights. You understand you're giving up and waiving all of those rights by pleading guilty.
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. If they said no, that would be the end of any appeal. Do you understand that?
Yes.
Has anyone threatened you with anything to get you to plead guilty? Has anyone promised you anything other than what was said here in court today?
No, sir.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you are guilty?
Yes.
This happened this year, January 15th or 16th of this year, is that correct?
Something like that, somewhere around there. It was mid-January. It was
Okay.
Wednesday evening.
Mid-January,
Yeah.
sounds right?
Yeah.
At that time, were you here in Kalkaska County?
Yes, sir.
And did you at that time have possession of some methamphetamine?
Yes, I did.
Did you know that that's what that was? Did you have any legal right to have any amount of it at that time?
No.
Mr. Ziegler, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Travis?
Yes, Your Honor.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Travis?
No, Your Honor.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Travis?
Yes, Your Honor.
All right, Ms. Brister, the court finds that your plea is knowing, voluntary, and accurate. Court is satisfied. There's a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that. It's important for you to stay in touch with Mr. Travis between now and then. And you're going to meet with Agent Brer up here today before you leave to set up a pre-sentence interview. Okay.
Thank you, sir.
Thank you. All right, Mr. Trepanier.
Okay. The court recalls People versus Trepanier.
Thank you, Your Honor. I appreciate the opportunity to have some discussion with my client about the final conference. We would be proceeding to trial, but we do appreciate the time to have a discussion about that.
Okay, so again, the trial is set for March 20th. The court will not accept any pleas after today, so Mr. Trepanier, that's how you want to proceed? Yes, sir. Okay, I just want counsel to be clear that if I get a call, and you, Mr. Trepanier, if I get a call on March 19th and you want to enter into a plea, the answer is going to be no. Will not. Yes, okay. All right, so Mr. Trepanier, I'll just ask that you and Mr. Travis are here ready to go by 8:30 on March 20th. Mr. Ziegler is sitting for review. we'll proceed with jury selection, move right into openings and proofs. Mr. Travis, are you anticipating any issues that we're going to need to address before the morning trial?
I don't believe so. Mr. Ziegler and I have discussed, obviously there's the tape and some edits to that. Given your honor's ruling, some of those edits we were going to make are not there, but we did discuss some portions earlier in the tape that he had just cut that I would like to get some pieces of that in there. So I think we will have a stipulated jury instruction talking about how the tape is chopped up and maybe a little bit more added. I think we agreed there'll be a little bit more. And other than that, I don't think there's really anything that I anticipate at this point. We do have I have subpoenas to the sheriff and I have another subpoena to a private process server, but those are all out as of yesterday. So yeah, over 2 weeks, I don't anticipate any problems there.
Okay, anything from your side, Mr. Ziegler?
Your Honor, I don't anticipate any issues. All of my subpoenas were mailed back in January. I don't anticipate any issues getting the necessary witnesses here. Mr. Travis and I are continuing to discuss the edits on the video, what exactly is going to be presented, and stipulated instruction regarding the fact that it's an edited tape, why it's edited. So we'll have all that worked out in advance of trial.
And Mr. Ziegler, have you already submitted your proposed instructions?
I don't recall if I had submitted them. I want to say that I did, Your Honor, prior to the last trial. But if I have not, I will get those.
Well, I'm just going to check.
Those submissions would not include the instruction. But I think everything else should be in there.
I don't see them in the file.
If it's a court file, Your Honor, I don't typically submit a copy to the court file because it's not really filing.
Okay, I'll check with my office. If we don't have them, then
Just have Jeff reach out to me. I believe I prepared them in advance of last time.
all right. And so, Mr. Travis, all you need to submit is just any objections you have to the prosecutors or any additional or different instructions you have. And then, of course, I'll look for the joint instruction. Playback.
Thank you.
Okay, I'll see everybody on the morning of March. Thank you.
Thank you.
Mr. Connolly. The court calls People versus Anthony and Joe Lambert. This is file number 255020.
All right, Ryan, say on behalf of People.
Your Honor, Matthew Connolly on behalf of Mr. Lambert.
So this was set for hearing at 11:45. We're a bit late. Mr. Lambert is present. Mr. Connolly, can you tell me from the defense side the status of this file?
Thank you, Your Honor. We would ask for one adjournment on this matter, waiting for a little bit of discovery, some video evidence, and one other issue that I won't put on the record that I just explained to the prosecuting attorney's office. So if we could have one more final conference date, Judge, we would appreciate that.
Mr. Ziegler?
Your Honor, I have no objection to the adjournment being requested. I'll look into whether or not there's video of the incident from the troopers.
Okay. So the court will set this for a plea hearing status conference in about 30 days. We'll go from there. Mr. Lambert, do you have any questions at all?
No, sir.
Okay. All right. Thank you. That's all.
Thank you, Your Honor.
Thank you.
It's the court's morning docket. The court will be at recess until 1:45.